Hi, I'm Alec Fair and I'm a Senior Solicitor in the Commercial Disputes team at Shepherd and Wedderburn. In this video, and the next on handling disputes in Scotland, we will discuss the disclosure of evidence relevant to court proceedings and the process for recovering evidence which is in the possession of someone else. We will focus on the disclosure and recovery of documents. Documents for this purpose can include maps, graphs, photographs and video recordings. A party to Scottish proceedings is not under a general obligation to disclose documents in their possession to the other parties, unless they expressly founded upon that document in its own pleadings. If they are not disclosed voluntarily, then an application must be made to the court to compel the party holding the documents, known as the haver, to disclose them. The haver is not always a party in the case. Often it is a solicitor. For those of you who are familiar with litigation in England and Wales, this is very different from the procedure there, where parties do have to disclose documents relevant to the dispute, both before proceedings are raised and during the action. The method for asking the court to order disclosure of documents depends on whether a court action is live or whether it is only in contemplation. In this video, we will look at disclosure of documents prior to court action. We will then look at disclosure once an action has been raised in a separate video. Parties contemplating litigation may want to see documents relevant to their case as part of their pre-action preparation. The only way to achieve disclosure of documents before formal proceedings have commenced, and in the absence of course of voluntary disclosure, is by obtaining what is called a Section 1 order under Section 1 of the Administration of Justice Scotland Act 1972. Our recent experience of Section 1 orders includes where a party has been concerned that evidence held electronically will be deleted. If you suspect that a party has documents that may be relevant to a potential action, and that they may conceal or destroy them if they are made aware that you want to recover them, a Section 1 order can be applied for ex parte, that is, without giving notice to the haver. Those are often referred to as dawn raids, as when the Section 1 order is granted, the person wanting the documents will often raid the haver's premises first thing in the morning to maintain the element of surprise and to protect against any documentation being destroyed. The test for an ex parte Section 1 order is very stringent, and there must be a real risk that evidence relevant to contemplated court proceedings is likely to be concealed or destroyed. The party making the application under Section 1 must have a prima facie case, that is, an arguable case on the face of it, that the documents exist and that they may be relevant to later court proceedings that are likely to be brought by or involving the party making the application. It is not necessary to show a prima facie case for the action that may later be brought itself, but the court will expect to have details of what it is likely to be about and how the documents sought are relevant to it. So-called fishing expeditions, where applications are made on the off chance that there may be relevant documents held which could give rise to an as yet unspecified claim, are not allowed. If a Section 1 order is granted, a commissioner is appointed, usually a senior advocate. The commissioner is often given the power to remove documents or property from the premises and to employ people to assist them. In our recent experience, that may involve an IT expert to properly search for electronic data that may be concealed. The Commissioner will also be given power to enter into and search premises where it is thought the documentation may be located. The Commissioner will be accompanied by a shorthand writer who acts as their clerk. Sometimes the court permits the applicant to also accompany them in order to identify property, but the applicant's solicitor shouldn't really assist the Commissioner, as that can lead to all sorts of conflict issues arising later. Havers that are subject to a Section 1 order can generally refuse to produce documents on the basis of confidentiality, the public interest, or self-incrimination, with some exceptions. As well as having experience applying for Section 1 orders, we also have experience of assisting clients who have been served with such an order through the dawn raid process. For more information on how to deal with a Section 1 order, please get in touch.